So you were nominated for Austin Woman of the Year.
Business
Woman of the Year.
Yes.
Tell us about that.
Yeah, so Awesome Businesswoman, they have like a magazine. And so I know of several like prior nominees and winners who have like been nominated. And so someone messaged me and they were like, "Hey, can I nominate you?" And I was like, yeah, that would be amazing." And so I think it's just like I don't know, I think they look for women who are influential in the community or like are heavily involved, and I do that. And so I just think this person thought I was a good fit, and so now you can vote for me because I was nominated.
So how do we vote for you? Is it an online voting thing?
Yeah, there's a link. Yeah.
Okay, so we just Google it or we go to their website. Where is this?
Yeah, you can go to their website and it's there's like different categories for voting. And so if you look under Awesome Businesswoman of the Year, you'll see my name. And so it would, I'd love to win. If not, it's just an honor to be nominated. It's really cool.
Yeah, that's pretty awesome.
Really cool.
Yeah.
And so, speaking of business, you represent a lot of business owners.
I do.
In bankruptcy cases, right?
Yeah.
And so oftentimes we think of bankruptcy as a bad thing, but sometimes businesses voluntarily put themselves into bankruptcy.
All the time, most of the time.
Yeah. And why is that?
Well, I think usually when you are contemplating bankruptcy, you are looking for a way to restructure. Like, I don't even like the word bankruptcy so much. I like the word like you're restructuring. And what that means is that you are just recategorizing and trying to figure out strategically what debts you can pay, what debts you can't, what debts should go away so that you can go on with your business.
Yeah. So when you're talking about thinking strategically, I'm assuming here we're talking about a business that maybe has run up a lot of debt. They're looking at their cash flows and they're thinking, hey, this isn't sustainable. We got to change something. Right. And so they hire a bankruptcy attorney maybe for some advice.
Yeah.
And they go through the process of the BK cases. So now, I've heard in my terms, Chapter 7, Chapter 11, Chapter 13. Sure. Can you give us a little bit of guidance on what the different chapters are and how they're used?
Yeah, so Chapter 7 can be used by businesses. And I know there's a misnomer that says, Chapter 7 is you're quickly exiting. But what I see a lot is that businesses file for Chapter 7 because they want to liquidate all of their debts. And that's what you use Chapter 7 for. You're just getting rid of all your debts and you are no longer operating your business. So if I have a client that comes to me and says, hey, I just want to restructure or, exit bankruptcy with a going concern, Chapter 7 isn't for you. So then we recommend a Chapter 11. And so what Chapter 11 is the debtor is a debtor in possession. And so that just means that there is no trustee and there is no one watching over you to make sure that what you put in your plan of reorganization is what you actually follow. I mean, there's certain parameters, but essentially you file a Chapter 11, you submit a plan of reorganization that just says, this is how I'm going to restructure my debts, and then the judge approves or denies it. And so at that point, you just follow whatever you put in your plan. So that's a Chapter 11. Then you have a Chapter 15, which is international debtors. And then you have a Chapter 13 and 12, which is mostly for individual. Well, Chapter 13 is all individuals. And then Chapter 12 is farmers.
Okay. So you mentioned a going concern. Sure. So what does that mean?
Yeah, so going concern just means that you are going to continue operating in some form or fashion. And that can only happen usually in a Chapter 11 because you have reorganized your debts and then you reemerge as the same company or as a different company, as the reorganized company.
Okay, so with a Chapter 7 then, you're liquidating all the assets and you're saying, hey, we're done.
Yep.
Make these go away, and we're not going to operate the company anymore. Yep. And in a Chapter 11, you're saying, hey, we've gotten ourselves in trouble. Can you make some of these debtors go away? But we want to continue the business. Yeah. Now, that sounds great, but let's get into the details here.
Yeah, sure.
So if I've lent money to a business who files for Chapter 11, and they go to the judge and say, Judge, we can't pay this guy back, and they're asking the judge to forgive some of their debt, what happens to me as a debt holder? Or do I get, how do I get compensated? What does that process look like?
Well, it really depends on your priority. So are you an unsecured creditor or someone that doesn't have any liens on any assets? Or are you a secured creditor who has liens on all the assets and can attempt to foreclose on all of those assets? So it really depends on your position. So the bankruptcy code provides for a list of priorities. And so administrative creditors get paid first, then it's usually secured creditors, then it's certain other creditors, then it's unsecured creditors. So there's a whole range of where you or the creditor could fall.
Okay, so this is where maybe we should have Matt on the show to talk about this because he understands
Well,
this stuff.
an unsecured creditor could just be I sued you and I have a judgment against you,
Right.
and for a lot of money, and now I'm coming after you, and I'm going to file bankruptcy to try to shake myself loose of that judgment. It could just be an unsecured loan. Here's a promissory note for some money. It could be a contractual obligation, like a lease would be an unsecured creditor. I'm kind of spitballing here. I don't know where they fall on the priority list, but they're not a secured creditor necessarily, depending on what's in the lease. And so if you're in a bad lease position or you have a location, maybe I've seen something like we have a location where it's like, I don't want this location anymore. I need to get out of this lease, or many leases. Maybe bankruptcy is something you explore to kind of shake yourself loose of some unsecured claims versus sorry, go ahead. Well, I was saying versus a secured claim where you have some lien against some assets, where if you default on those assets or you go into bankruptcy, the lender would have a claim on that asset. Car and a house are very common ones. Real estate's a common one, but it could be bank accounts or other personal property or equipment where you might have a lender might have a lien, and that process you'll be treated differently in bankruptcy because you have a claim to an asset that you can go take and sell.
Sure. Right. Well, and I think you bring up a good point for those creditors who may end up in bad lease positions, let's say. It's important when you're doing those contractual negotiations to figure out and think ahead of what the possible bankruptcy implications may be. Because I think sometimes... So what I mean by that is if we have a landlord who comes to us and says, hey, I'm thinking of entering into this agreement with the tenant. How can I make sure that I am protected in all ways? And what we would recommend at that point is make sure that you have some kind of security interest so that when you do, let's say the tenant does file for bankruptcy, you are in a better position than you would have been had you not come to us and gotten some advice on that in the front end.
Right. So it's possible then that a business goes to court and says, hey, I've run into trouble here. I've racked up too much debt. I don't have enough money to service all this debt. Let's restructure here. And somebody in this case that is an unsecured creditor, the judge might say to them, sorry, but we're wiping your debt. It's gone. It could happen.
It could happen. Yes.
It could happen.
It could happen.
So how does the system balance the fairness in situations like this?
Well, to be honest, the system does account for that. And you'll hear some bankruptcy practitioners say, and I'm pretty sure the code even has some provisions for this, that says that for a bankruptcy to make sense and for a debtor to be able to file for bankruptcy, there has to be a positive outcome for the unsecured creditors.
Okay.
And so obviously this doesn't happen in practice, but ideally the idea is that you have enough money to go to your unsecured creditors. So that way everyone is not made whole, but you are able to recover some of the money that you've put out.
Okay, so basically, let's make the best out of the situation,
Exactly.
knowing that we want to avoid the complete disaster where nobody gets paid.
Yeah, the idea is never to, mess over your unsecured creditors. That's not the idea.
Right.
The idea is that they do recover in some way.
So it becomes a point of negotiation. Then,
Right.
what's that old saying? If I owe you $1, you own me, but if I owe you $1 million, I own you.
Right.
Right. So it's the same concept. So a lot of times when it gets to BK, one would be much better off, as you mentioned early on, negotiating and understanding what ramifications might happen if this does happen, and getting really good counsel. Now, so different parties in BK cases, in bankruptcy cases. So obviously we have the business itself, the business owner, that might have some debt that they need to pay. You have the person that actually gave the money, whether it's secured or unsecured, equity or debt. And then oftentimes we hear the terms the bankruptcy trustee. Who are these folks?
Sure. So the bankruptcy trustees really show up in subchapter 5, chapter 11 cases. And then you also see them show up in chapter 13 and chapter 7 cases. And so they play a different role depending on the chapter. But I think chapter 13 and 11 trustees, sub 5, chapter 11 trustees, are similar in the sense that they are there to govern and watch over what the debtors are doing. And what I mean by that is you will have 341 meetings where the debtor will show up and has to answer all of the questions that the trustee has. The trustee steps into the shoes of the debtor and is able to enact litigation against any preference litigants. The trustee can go after non-exempt assets. So the trustee has any powers that you as the debtor would have had under non-bankruptcy law. And so the trustee is very powerful. I would say almost, if not more powerful than the judge, right? Because the trustee is the one making all the moves.
And the trustee is appointed by the judge, by the court?
By the court. So the court has like this trustee panel. And so the panel of trustees, they get selected for cases. So, and I'm pretty sure it's a random selection.
Okay.
So there's just this panel and they get picked.
Okay. So let's walk through this process from start to finish.
Okay.
So business owner, when we're talking here, lower middle market business, and oftentimes these are personal guarantee debt, right? But let's put that aside for now. They come to counsel. They say, hey, we see a potential problem here. We're thinking about BK as the option. And let's say you've come to that agreement. What does that process look like? So you said, okay, this is the right step here. Walk us through the steps.
Yeah. Well, I mean, and I could see a situation where, and I understand in bankruptcy, timing can be a big key, but I can see like one of our clients coming to you or me and saying, I don't know how to deal with my debt situation or claim situation, but I need to save my business.
Mm-hmm.
I need to get through this process and I still have a business. What should I do? How should I get there?
Right. So let's take one of my clients. I have a client who wants to file for Chapter 11. They own a business and they defaulted on their loan. And so their loan is now being called. And so time is of the essence, right? Because you want to make sure, because that creditor has a security interest and come get all of the equipment, right, for the loan that's being called. So you want to make sure that you file for bankruptcy before the creditor can come get the assets. And so that means that you are working against the clock to get schedules filed, which is just a list of debts and assets, right? So you want to make sure that you get that on file as quickly as possible so that you can trigger the automatic stay. And so the automatic stay stops and halts everything. So that means my client can't receive collection letters. They can't receive any foreclosure notices. No one can have contact with my client once the automatic stay is in effect. And so that's really nice because it provides some breathing room, right? So then you can put your client in a position where you file the schedules. You can attend the 341 meeting. You can file your cash collateral motions, your utility motions. You can get everything in place so that your client can exit and continue on with their operations. So once we do those first day hearings, so your cash collateral motion, your utility motion, which is just you asking the court to use cash or to continue paying your utilities. So once you've done that, you will generally, if everything goes right and smooth, you will at that point file a plan of reorganization where you say, hey, I am proposing to pay these secured creditors over this amount of time. I'm proposing to pay these administrative expenses in the ordinary course. I am proposing to have an unsecured pool of this much money to go towards my unsecured creditors, and this is within the time that I'm doing that. Ideally, if a judge reviews it, there are no objections from creditors. You can be in and out. They call them pre-packs. You can be in and out within 30 days. That is if nothing goes wrong. Obviously, that hardly ever happens, but it's happened. It's happened.
Yeah.
And so at that point, once your plan of reorganization gets confirmed, it is just the debtor's job to pay in accordance with the plan of reorganization.
Okay. So in this scenario, very rosy picture here.
Right.
Basically, somebody might have certain terms that they cannot meet. For example, hypothetically speaking, they owe X number of dollars every month in payments. They can't meet that for whatever reason. They basically say, hey, we're going to restructure this, and instead of paying you $10,000 a month, we're going to pay you $5,000 over a longer period of time. Right. In essence, they're getting the judge to say, yep, go ahead and alter the agreement. Right. That's what's happening. Sure. And in other cases where not everything goes well, what happens then?
Yeah. So the creditors come in and they say, no, I don't like that I'm being paid over X amount of years because I feel, or the code provides that I'm entitled to X amount of dollars, X amount of years, X amount of interest rate. And so when that happens, which that's what usually happens, there's a lot of fighting, and that's when the litigation starts. That's when the adversary proceedings start, where you are fighting and fighting until the judge makes a decision, and either you pay the creditors as you agreed to in the plan, but more often you will amend the plan and negotiate to come to a middle ground and put that in the plan instead. And so obviously you want a consensual plan, right? Where all of the creditors agree to what you're proposing and you go on about your...
Yeah, and so what's interesting about this phase is if the creditor wants to put their foot down and say, no, we want X. Sure. And the debtor says, well, we're going to fight this. Ultimately, there's money being spent on litigation, which means that there's less money to collect, even if it does sell. Exactly all parties have to agree. So this is then what we're referring to as sometimes as a strategy, the business that owes money will force bankruptcy to kind of twist the arm of the bank or the lender or the equity holder, whoever, in negotiations. Now, you've done work where you've represented multiple sides, right? Sure. Not at the same time, obviously. Yeah, so give us some insight into the mindset of the different actors. So let's start with the business owner, okay, or the business itself. Yeah. What are they thinking when they're looking at bankruptcy as an option?
So they are either panicked or strategic. It depends. I feel like you fall in either one of two camps, right? Like either you understand that bankruptcy can be a very helpful mechanism, or you are under the impression that bankruptcy will ruin your company forever. And I think that's so unfortunate because it was created to help people and to help businesses. And so I think this podcast is great for the reason that hopefully we can enlighten some people and let them know that bankruptcy can actually be very strategic and you can come out far better than you were before.
Well, I was saying before we kind of get to the other players, I've heard a lot of bankruptcy colleagues say, come to us early. And we talk about this all the time about coming to professionals early. But in the instance, maybe not in this particular instance, but you mentioned an example where your debtor client was already in default.
Right.
Would the leverage or outcome possibly be better if they came to you 6 months before they
absolutely
default?
Right, because we could have started those negotiations early instead of filing a panicked bankruptcy, right? We could have negotiated with our creditors' lawyers and we could have figured out like, hey, can we come to some sort of middle ground where this is what we can offer you in exchange for XYZ? That would be ideal. But unfortunately, that just doesn't happen very often.
Yeah.
No.
Yeah. And speaking of looking at bankruptcy as strategic rather than as a bad thing, I mean, how many times have you heard major U.S. corporations that reorganize and come out stronger than before? And sometimes, multiple times throughout their history. Okay, so that's the business.
Better. Yeah.
What about from the perspective of the creditor?
Yeah.
And you touched upon there's multiple types of creditors.
Sure.
So unsecured creditors, secured creditors, equity holders. What are they thinking when they're going into these potential BK situations?
Sure. So if you're a secured creditor, you're thinking, yay, like not yay. I mean, maybe that's a little bit over dramatic, but you know that your position is covered. So for example, I represented taxing authorities for a very long time. And taxing authorities have a statutory lien. And so they are covered like in the Constitution. They're covered in they have their own code. So they have a very strong position. So when bankruptcy happens for taxing authorities, they're like, I mean, okay, not great, but I have a way of collecting my dollars. Compare that to unsecured creditors for, like Jack said, let's say they have a judgment and they were wronged in some way. I mean, you have tort claimants who have judgments, but it doesn't mean anything if the debtor doesn't have any money. So if I'm a tort claimant, that's devastating. Bankruptcy can be devastating for any recovery I may have. And obviously it depends on the circumstance, but it may not be a great position always for a tort claimant. It just depends.
Yeah. So we've heard Matt talk about the positions. So you got senior debt, right? And then you got junior debt, you got the mezz lenders, and then at the very bottom, and we've recently in the news with some banks going under, the shareholders, the equity holders, they're the last ones to collect, if any. And so in those situations, we've talked about on the business owner side, they could start the proceedings themselves. What protections do the debtors or the creditors have at this point, or is all their leverage upfront in their agreements? How are they? What should they do?
Yeah. So I don't know that there's much you can do to prevent a debtor from filing for bankruptcy. But again, if you have that security interest, like that's almost like gold, right? And obviously some creditors can't get a security interest. I mean, and to go back to the unsecured creditor piece, there are steps that you can take, right? Like you can abstract your judgment, or there are things that you can do to make sure that you have a security interest. But for those secured creditors, let's say, you need to hire a bankruptcy counsel because you need someone who can participate in those bankruptcies on your behalf. And I think if you do that, bankruptcy was designed for an 8th grade person, right? But it is not actually very doable for the 8th grade mentality or person. And so you need someone who can protect any rights that you may have, because it's very hard to go in pro se and try to figure things out yourself.
Right. Okay. And I guess for the creditor side, it all comes down to better do your due diligence up front.
Yeah, exactly.
Do good underwriting before you throw money and give money to people. Okay. And then on the trustee side, you mentioned that the trustee steps in on behalf of the debtor,
Right.
and they could start litigation and everything else. So they're basically the debtors or they hire counsel to take them to BK, but then once they're there, the trustee now hires, or what does that look like?
Yeah, so although the trustee steps into the shoes of the debtor, the trustee is a separate third party and is not in any way protecting the interests of the debtor, so to speak.
Okay.
Right? The trustee is doing what is best for creditors. Or what's best for the estate. The trustee is not in any way representing the debtor.
So they're trying to protect the business's interest,
right.
or the creditor's interest?
They're trying to protect the estate's interest. And what I mean by that is you have to do a balancing act of making sure that the debtor isn't harmed in any way, that your creditors are being made whole, or as whole as possible. And then you also have to make sure that you protect the estate, and the estate is anything that the debtor owns.
Okay.
So you are protecting this realm of being.
I got you. So basically their interest is to protect the rights of people that ultimately own this asset. They want to preserve the assets.
Sure. Yes.
Yeah.
Okay.
Yeah.
In a lot of ways, they're like, when you said step into the shoes, they're like a new business owner.
They're fiduciary.
Yeah, because they're looking
fiduciary.
They're looking at the whole estate. They're trying to understand. They're trying to understand what claims they have or rights they have.
Right.
How can we best use any collateral we have to maximize the estate's value? Because some collateral has an expiration date on it.
Right.
And how do we overall maximize the estate so everybody hopefully gets a piece of the metaphorical pie?
Right.
And it's not just a complete crater or meltdown of what could be some value for the creditors and the ongoing concern. I mean, from a viewpoint you said strategic, bankruptcy is there in some ways to protect value that otherwise could just go completely vanish, because there's all these creditors knocking at the door wanting to get paid, and maybe it's your favorite creditor or the biggest muscle that is going to get paid, where that doesn't make sense from a value maximization standpoint.
Right.
Yeah, you guys have taught me a new word that I'm going to add to my lexicon here: ongoing concern. I like that, an ongoing concern. So let's talk a little bit about BK cases that go across state borders, and you've done work in those cases.
Right.
So how does it work? Hypothetical case: we have an enterprise here in Texas, and we have money flowing in from both coasts, right? Let's say private equity from California and New York. We'll just use that as an example. What's the venue? How does that get decided? And then let's talk a little bit about the differences in how Texas looks at BK and how maybe a place like California looks at BK.
Yeah, so it's an interesting way that things are set up. But generally, you can file where you are doing business, or where your principal place of business is, or where you're registered to do business. And so what you'll see a lot is that businesses will register in Texas or Delaware because they are favorable. And so you will have the biggest bankruptcy filings, like for large corporations, you'll see in the Southern District of Texas and in the District of Delaware. And that is very strategic.
So Texas is on par with Delaware as far as where these
specifically the Southern District.
And what is the Southern District of Texas encompass? Is that Houston? So
that's Houston. And just the surrounding area. So it goes all the way to the border.
Okay.
But it's like Houston in
it's like
particular
wow. We're not just the fourth largest city anymore. We're
the bankruptcy, like one of the bankruptcy capitals.
So Texas is open for business.
Yeah, it is.
Okay.
Which makes sense, right?
Right.
And so you see a lot of filings here. So you have, I mean, like anyone who has everyone files here in Delaware.
Okay.
Yeah.
And so if in this example where we have creditors in California, let's say, and the enterprise is operating or registered here in the Southern District of Texas, this is the venue this
is where they'll go.
And can a creditor fight to say, hey, no, change of venue?
I mean, they can, but you don't really see that. It's not like federal court where you're like trying to remove cases to different states. Like you go to wherever the bankruptcy is, and you'll just hire local counsel in whatever state you are wanting to participate in.
So now I've seen this, Jack, in M&A transactions where there's clause in there that says in case of dispute, we're going to use laws in this jurisdiction or that jurisdiction. How much does that play into the negotiations when we're thinking, if I'm selling a business and I know we got, maybe better, more favorable way that the courts look at in an example that's favorable to me, let's say that I want that in there. How much does that play into it?
Well, I mean, so it's an interesting question, right? And we're kind of in a different world when we go into bankruptcy. So let's say that, let's say you have an earnout.
Yes.
And you're the party you have an earn against files bankruptcy. You're going to bankruptcy court.
Right.
And so the venue, wherever that court is, it's probably going to be the bankruptcy court venue. Right. And then they have like a mini lawsuit within the bankruptcy case, and those principles that you applied, whether it was laws of Delaware, laws of Texas, whatever, would be supposed to be applied by the court.
Right.
And you have this basically mini lawsuit, and it's negotiated. But if a judge needs to step in, they'll make a determination, and then you go in line with the creditors. So if you're an unsecured creditor, and let's say you have an earnout, $1 million earnout, you have $1 million unsecured claim that you'll have to go wait in line for it.
And you got to go to the jurisdiction of the bankruptcy jurisdiction, not necessarily the dispute resolution venue for the M&A transaction itself.
Right. But like Jack said, those laws from that whatever venue was picked in the contract are supposed to be applied.
Mm-hmm. Yeah.
And the bank's lawyers, because private equity has some lending, they'll be coming in and arguing about where your place in line is and when you get paid. And so it's bringing all these different, you have your claims, the bank's going to have their claims, and we're all at the table now discussing and negotiating in a very, I would say minimal, but very quick way about how this is all going to get resolved.
And so
efficiency.
All of a sudden, talking to you guys, earnouts don't seem to be that appealing anymore. It's kind of scary, potentially. So in your experience, you're saying the Texas courts or the Southern District is more favorable towards debtors here?
I don't want to say that they're more favorable, but I think they are used to efficiently handling large corporate bankruptcies.
Okay.
And usually the goal is to be in and out as quickly as possible. And I think the judges in the Southern District and in Delaware have mastered that.
Okay. What about for the clients that we see most of the time, lower middle market, privately held enterprise? Is there a difference between how they're handled and these mega corporations are handled?
No, not generally. I even smaller or like mid-range businesses are still filing in Delaware or the Southern District.
Okay.
Yeah.
Okay. So not much difference in the process, same process, and the venues, no difference in the outcomes from there.
Right.
And so in a case where you have these creditors in one part of the country and you have the enterprise here, you mentioned that those out-of-towners would have to hire local counsel here. So that's going to drive up the cost more. Now, is that a strategy? Is that something that goes into the strategy when a business owner is looking at the BK situation and they're looking to see where their creditors are? So for example, if they got a loan from a local bank, let's call it a regional bank, that's one thing. But if they got these out-of-towners, and maybe it's not private equity, maybe it's a private placement of some sort, where they're looking at this and they're saying, it's going to be really expensive for this person. Is does that go into the strategy when you're looking at strategy of going to BK? Are those variables taken into account when you're formulating an overall strategy?
I think all variables are taken into account. I don't know that I would say I won't say that, but I have never had a circumstance with my client where I've said, hey, let's file here so that this creditor spends more time to get to you, right? Because that's not usually the approach we're taking. We're more so taking the approach, what is most efficient for this client and how can we get them in and out as fast as possible? So is it an added benefit that maybe it's more expensive for this creditor, so they may be more willing to negotiate? Sure. But is that a big factor that I take into account in counseling my client? Usually not.
Okay. So, I've heard this saying before, maybe it's a myth, where the lawyer will say, I will bury you in so much paperwork and motions that, you're not going to want to go through with this.
Sure.
So that's not necessarily the case.
Well, it's not a myth. I think that maybe they've provided some ethics guidance.
Yeah, there you go. Now, once you take on a business owner in a case like this, I'm assuming that third parties are brought in, maybe some CPAs, maybe some accountants. Who are the different players that typically, when it goes down this path, that are brought in to help out?
Yeah, you have your financial advisors, you'll have real estate agents, auctioneers, real estate brokers, anything. You'll have divorce lawyers. I mean, what you have to think about bankruptcy, it is you are dealing with everything that you would in the ordinary course of business. You're just dealing with it in a bankruptcy situation. So anything that the debtor might need within that circumstance is who you hire. So if you need a financial advisor, if we are selling some real estate, you'll need a broker. If we are auctioning off property, you'll need an auctioneer. So it's all of those people that you would just hire into the bankruptcy situation.
Okay. And when it goes to a trustee, I'm assuming the trustee's got free reign to hire whoever they want, and you kind of lose control as the debtor at that point.
Yeah. So they have free reign to a certain extent, but they also have to take into the account because they're spending the estate's dollars. So they have to take into account, well, does this maximize value? Does this make the most sense? So sometimes trustees work with debtors, sometimes they don't. It just depends on who's providing the best deal to the trustee to get this done.
Yeah, so they're carrying out their fiduciary responsibility.
Exactly.
So in your experience, is there a typical pattern that gets people in trouble to the point where the business goes into BKs? Are there certain things that you see over and over that's led to a bankruptcy situation?
Personal guarantees are a big problem for small business owners because they'll sign personal guarantees, and I don't think they fully realize that they are then responsible for that debt in the event something happens to the business. So then not only are you doing the business filing, you're then also doing the personal filing. That is a big issue. And then I think just over leveraging, right? You aren't strategic in your long-term financial planning and you over leverage and then have to file. So I think those are the two big things that I see that get people in trouble.
So over leveraging causes them to get in trouble. And then the personal guarantees is the double whammy. They're like, now I also own.
Exactly.
Now, where is the accountability for these lenders who are providing these facilities? They should know better than to lever them up this much, right? Is that an argument you guys make in court?
I mean, possibly, but that's almost like a morality thing, right? You should have known better than to loan all of this money to this
predatory lending, right?
But it still happens, right? Yeah. I mean, it's even worse now than
well, you ask any business owner, and they'll tell you, 99.9% of business owners will tell you this, that when they need money, the banks don't want to give them money. And when they don't need money, the banks are calling them to give them money, right? And so over leveraging becomes a really big problem. And I think, the economic cycle right now where credit's about to tighten, all those folks that, during COVID, I mean, just take the example of used car prices. Remember how expensive they got, right? And and interest rates now are going up. So if they had an adjustable rate, all of a sudden they have all these bigger payments coming due, and maybe the car prices have come down now, and it's a used car, what's going to happen there? So over leveraging is a big problem. And just look at the credit card debt, the household credit card debt numbers. It's a scary thing. And finally, the final topic I want to talk to you about today is you mentioned if they do the personal guarantee, it flows over to their personal side. At that point, are they hiring different counsel to handle the personal side? Is there any conflict of interest there? If there's, because there's creditors on the business side, how does that play out?
Yeah. And again, I hate to say this, but it really just does depend on the circumstances. Sometimes we are conflicted out, but other times we can handle both bankruptcies because really so you can almost do a jointly administered case because they work so closely together. And so that we've done that, and that's always an option.
Yeah.
So again, it depends. Yeah.
And Jack, this is why, we talked a little bit with Christine last time, but estate planning for business owners is so important, right? And we should probably do a whole show on asset protection.
Yeah.
But,
definitely.
Imagine somebody goes into a situation like this where, it's their blood, sweat, and tears. It's their baby. They've grown the business. And now for whatever reason, they've run into financial trouble. And everything they've ever worked their entire life for, the business is at risk, but also, business owners, they put everything right back into the business. Now their personal lives are potentially uprooted. So proper planning becomes so important. And I think my biggest takeaway from this conversation is if the first time you're talking to a BK attorney is once you're in BK, you probably did something wrong. You should have been talking to your advisors, your attorneys up front. Any last advice for business? Yeah, go ahead, Jack.
Well, we were talking about the various professionals involved in bankruptcy. Sometimes bankruptcy is used for M&A. And it's becoming more and more commonplace to see bankruptcy as a platform or as an avenue to take an over-levered business or a business that can't pay its debts or needs to restructure, but it's an opportunity to exit. I mean, we talked in the beginning of the show about I want to hold on to my business. Well, if I want to exit, bankruptcy might be the best way to exit, because if you have an over-levered business and your sales price is not going to cover the debt service or the debt, maybe we should be looking at bankruptcy as a way to get rid of the debt and also get you kind of free from the business and find somebody who can take it and provide value. And maybe there's a strategic avenue there for to continue the business on, because it is a valuable, as you said, ongoing concern.
Yeah. Well, in that case, though, if let's play that out. If somebody puts the company into BK, then what happens? Is there an auction that happens?
I mean, it potentially. It depends on what negotiations occur, because sometimes you decide, okay, I just want to sell this off and walk away, right? So that's when an auction would occur. But sometimes you also just take on new debt. You restructure that debt and say, nope, I'm just going to reemerge as the same company or the reorganized company.
Yeah. Now, I've heard the term stalking horse in bankruptcy.
Sure.
What is that?
So stalking horse comes up in an auction setting where the stalking horse bidder is the initial bidder to set like the starting floor of the bid. And so the reason why they've created this term is so that you don't have low bids, right? Like you want to prevent people coming into bankruptcy situations and lowballing.
Okay.
And so this kind of sets the floor. And so as the stalking horse bid, anyone can come in and overbid you, but you always know that if no one overbids, the stalking horse bidder is the winning bidder. And so it provides some structure, and it prevents the lowball offers.
And is the stalking horse bidder working in conjunction with the debtor here?
No. So the stalking horse bidder is a third party who has been fully vetted and made sure that they have the qualifications to place a bid. And so they're just you or I coming in and saying, hey, we want to buy these assets.
Okay, so someone's reaching out to them, say, hey, we want you to bid on this thing.
Or no, not even.
No.
It's like, hey, we are going to market this property, and the first person that comes in, we will mark as the stalking horse bidder. And then thereafter, people come in and say, no, I want to bid. Let's say, I don't know, I bid $1 million on this piece of fabulous lake property. And someone comes in and they're like, no, I want to bid 1.5. So the stalking horse bidder then goes away because they're the initial bid. But no one can come in and say, oh, I'll bid 500,000. No, we can't let you in.
Okay, so there's terms that say we're not going to take anything less than as a starting point.
Right.
Okay. And typically, who are these stalking horses? Are there certain? Is this something strategically that people reach out to, or it's just a general term that the first person that sets the floor is the stalking horse?
So generally, stalking horse bidders are just either maybe trustees know of these third-party entities who like to buy up things in bankruptcy, right?
Okay.
So they could reach out and say, hey, I have this property. Are you interested?
So it's an indirect way of having a minimum valuation set, kind of.
Yeah.
And in the M&A context, it could be, I'm trying to grow my business. I know this competitor just went into bankruptcy, and now I want to make an acquisition because I know there's value there. I can take it and make a lot of money from it. And you'll start pretty much a similar M&A process. You're doing diligence.
Yeah. Right.
You're negotiating terms.
Okay. Any parting words for business owners who might potentially get themselves in financial trouble by being over levered? And what would you tell them to watch out for?
I would tell them to hire legal counsel before they think they need legal counsel, and I would tell them that not only are bankruptcy lawyers, they can also help you restructure before filing. Like there's so much work that we can do and pre-plan for you to potentially avoid bankruptcy. So if you even have an inkling that, oh, things aren't looking good, come see us. Come see us because we can help you. We can restructure some of those debts for you.
I like that term, restructuring.
Yeah.
We're getting rid of BK.
Right.
We're going to call it restructuring specialist.
Yeah,
There's
there
actually
you go.
a lot of law firms that have remarketed their bankruptcy group into the restructuring group.
I like it. So workouts, like, I mean, aren't there
exactly.
Aren't there whole like consulting firms out there?
There are who just do workouts.
Yeah.
Out of court workouts. Yeah.
Restructuring.
Yeah.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.